Good morning, everyone. This is the Office of Immigrant Affairs Housing Security during the Pandemic webinar. We are joined today by Mr. Daniel Sharp from the Los Angeles County Office of Immigrant Affairs. Mr. Sharp, the floor is yours.
Thank you, Jorge. Thank you, everyone, for joining us today. We're excited about today's presentation. We have a lot of useful information that we hope you can benefit from and share out afterwards as well. Because our agenda is so full today, we are not going to be taking live Q&A at the end of the presentation. However, if you have questions that you want to post in the chat or contact us afterwards, we will be circulating any questions that come up during the presentation to the participants. So please take advantage of that opportunity. Jorge, if you can advance the slide, please. So for those who are not familiar with the Office of Immigrant Affairs, we exist to, among other things, support immigrants who live, work, and do business in the county, to connect with the services and support that they need to not only survive during this pandemic and these difficult times, but to thrive in their communities. If you need support for individual immigrant families that you work with, they have questions about access to services, we are available Monday through Friday, 8 a.m. 5 p.m. Our phone number is here on the screen. Please feel free to reach out about access to county services and other needs that immigrants and their families have during the pandemic and otherwise. And Jorge, next slide, please. And then I also want to lift up our social media and our Facebook availability. We expect as we have a new administration, significant changes in the immigration landscape. There will be frequent and significant updates for immigrant communities in Los Angeles and around the nation. If you want to stay up to speed on those developments and the webinars that we'll be having about many of those issues, please do follow us on our website, Facebook, and Twitter. And then this recording will be available as well on our Facebook page afterwards. Next slide, please, Jorge. So I'm really excited about today's conversation, and it is so important for a number of reasons. We know that the rental burden in Los Angeles is high for everyone. This is a location where the rising cost of rent has been an issue for years, and it disproportionately impacts immigrant households. Many immigrant households spend half, some up to 2/3 of their household budget on rent. This was a problem before the pandemic, as immigrant workers faced job losses, reduction in hours, and a disproportionate need to isolate and quarantine due to job-related COVID exposure. This burden has only increased, the struggle to pay rent. And so while eviction moratoria and other renter protections have been enacted by the county, by various cities, and then even the state and federal governments, we know that those protections are not restricted based on immigration status. We know that some landlords have taken advantage of immigrant tenants by threatening to call immigration and customs enforcement on them. So today we'll hear from Manny Ruiz from our Department of Consumer and Business Affairs about the county's new Stay Housed LA initiative, which educates those living in the county about tenants' rights, legal resources that they can access if they need assistance. And then Scott Davis, we're thrilled to have with us from the Inner City Law Center to discuss what to do if you're threatened with eviction, what your options are. And then also we know homeownership is the dream of many, and actually many immigrant Angelenos are homeowners, and ownership is actually higher among naturalized citizens in LA County than it is among US-born citizens. But homeowners too are facing pressure during the pandemic and the economic uncertainty. And immigrant homeowners are often victims of scams related to mortgage refinance and otherwise. So Sam Lukin from the Department of Consumer and Business Affairs will talk about some of those scams when someone is falsely offering foreclosure prevention opportunities to families. And so if we can move forward to the next slide. Before we jump into this really rich content from our three speakers, I do want to lift up this issue of public charge. This rule change that the federal government enacted on February 24th, just before the pandemic started. I do want to note that this has loomed over immigrant families' concerns about and their ability to access public benefits throughout this entire year and throughout the pandemic. I do want to note that the protections and the benefits that we'll be discussing today do not have any public charge implications. In reality, this public charge rule, while it has had a terrible chilling effect and prevented immigrant families or deterred immigrant families from accessing certain benefits, in reality, it only applies to certain immigrants at certain stages of immigration processes, and it only applies to certain forms of public assistance. If we can move forward one more slide, please. So as you'll see, I want to leave this in here more for reference, but the big takeaway here is that most immigrants who are subject to a public charge test, a determination of whether they're eligible for permanent residence or not, based on whether they may rely on certain forms of public assistance in the future. Most immigrants who are subject to this test just aren't eligible for the benefits that are considered under this public charge rule. So on the right, you see what some of the benefits that are now considered in this new public charge rule are: cash assistance, food stamps, federal housing assistance, and long-term institutionalized care. Most immigrants seeking to obtain legal permanent residence who undergo a public charge test are simply not eligible for those benefits that you see on the right of your screen. And then benefits received by eligible household members, such as US citizen children, are not factored into an immigrant parent's public charge test if that parent is seeking permanent immigration status. So I do want to note that our office has received over 2,000 calls about public charge during the pandemic, the vast majority of them from immigrants who are concerned about accessing a particular benefit when in fact that benefit is not considered in the public charge test. If we can move forward one more slide, please. Notes a lot of the important benefits that are not considered. And so this includes our critical health benefits. US Citizenship and Immigration Services clarified at the outset of the pandemic that any COVID-related testing, treatment, and then preventative care, when we have that, hopefully very soon, will not be considered in any immigrant's future public charge test. And then state and locally funded health programs like Medi-Cal that is now available to all Californians up to age 26, regardless of immigration status. For undocumented individuals and persons with DACA and less than permanent immigration status, they're not eligible for federal Medicaid. They qualify for this California-funded Medi-Cal program that is not considered in a public charge test. When a person turns 26 in Los Angeles and loses their Medi-Cal eligibility, they're eligible for our local program, My Health LA, locally funded and does not have public charge implications. Similarly, many of the important earned employment benefits, disability, paid family leave, workers' compensation, and then unemployment for those immigrant workers who qualify for it. They must have employment authorization to qualify for unemployment. Those earned benefits are not factored into the public charge test. Similarly, emergency benefits, including emergency housing support, is not considered in a public charge test. And as I mentioned before, benefits received by household members, such as US citizen children who may qualify for other benefits, are not considered in their parents' test. So I just want to note that, and if we can, with that, we'll move on to the bulk of the presentation. But if you have questions, if you are working with individuals who have concerns about accessing a benefit and the immigration implications of that, please contact our office. We are available throughout the week to answer individual questions about public charge implications of benefits. So if we can move forward to the next slide, please. And so with that, I'm going to give the floor to Manny Ruiz to discuss the Stay Housed LA program. Thank you.
Thanks, Dan. So first, I want to thank the Office of Immigrant Affairs for inviting me to share this critical information regarding the county's eviction prevention and defense services. I think right now, as Dan so eloquently put it, is a tough time for a lot of vulnerable communities, including our immigrant communities. And the county is taking very proactive steps to assist, to help stabilize households through various different programs. And so I'm going to talk today about our Stay Housed LA County program, which is the umbrella term kind of branding for our eviction defense services. So again, my name is Manny Ruiz. I'm a senior policy analyst with the Department of Consumer Business Affairs. And so I'm more than happy to be here with you today to share all this information. So next slide, please. So before going into the details regarding the Stay Housed program, I just wanted to give you an overview about the Department of Consumer Business Affairs. So we're a department that serves consumers, businesses, and communities through education, advocacy, and complaint resolution. So our mission is to create a fair and vibrant marketplace for consumers and businesses, and we do this through a plethora of different programs. So we have programs for consumer protection, small claims and mediation. We have an Office of Small Business, the Housing and Tenant Protections Division, which oversees the Stay Housed program, which I will talk about. We also have a Center for Financial Empowerment. We have a wage enforcement program. The Office of Immigrant Affairs sits within the Department of Consumer Business Affairs. We also have a foreclosure prevention program. Next slide, please. So, as I mentioned, the DCBA Housing and Tenant Protections Division oversees the Stay Housed LA County program, but that's not the only thing that they do. The Housing and Tenant Protections Unit also oversees the implementation and enforcement of various tenant protections and laws in the county. Primarily, they oversee implementation and enforcement of the county's rent stabilization ordinance. So if you live in an unincorporated part of the county, in a rent-controlled unit, this ordinance oversees kind of enforcement and guidelines that dictate the kind of annual increases and other just cause protections you have as a tenant. They also oversee the county's mobile home rent stabilization ordinance, which applies to space renters that live in mobile home parks. We also oversee implementation and enforcement of the county's eviction moratorium. So during the COVID-19 pandemic, the Board of Supervisors implemented an emergency order that put a halt on evictions for households affected by the COVID-19 pandemic. And so we oversee implementation of that particular emergency order. And as I mentioned, we oversee the Stay Housed LA County, which is the eviction defense program. And so if you have any general questions, resources that you want to access about any of these, including Stay Housed, you can contact us through the information that's up on your slide right now. We will also be repeating this information at the end of the presentation for anybody interested in connecting with us. Next slide, please. One other large resource that our department offers in partnership with the Department of Workforce Development, Aging and Community Services and other departments is the LA County Disaster Help Center. So this is kind of an entryway portal into various county services targeted towards businesses, workers, nonprofits, and also for any tenants and landlords that might be seeking resources. So, we encourage individuals to either try to contact our department, the Stay Housed program, or the LA County Disaster Help Center for any resources that you might be available to. It's various entry points into our system for access to services. And the Disaster Help Center is open every day from 8:30 a.m. to 5:30 p.m. It's countywide, and they provide assistance in multiple languages, including English, Spanish, Korean, Mandarin, and Armenian. Okay, next slide, please. So what I'm here to talk about, the Stay Housed LA County program. So we really are excited to have launched this program in September of this year, which is a $12.7 million program that really operates as the first line of defense against mass evictions and homelessness in the county. This is a really unique type of a program. There's several other jurisdictions across the country that have these types of eviction defense programs, such as New York, San Francisco, Philadelphia, Newark, New Jersey. And so here in Southern California, this is the first type of program under this eviction defense kind of umbrella. And it's really unique because it brings together various partner organizations that are members of this organization called the Rights of Counsel Coalition, that include legal service providers, community-based organizations that have the expertise and cultural competence to work in a lot of these vulnerable communities, and specifically with tenants. And so we know that right now, over 500,000 people have lost jobs ever since the start of this pandemic. We also know that about 90% of landlords that are seeking to evict tenants have legal representation, and about 90% of tenants don't have legal representation. So this program is really meant to try to create a level playing field for tenants, so that if you're in danger of losing your housing, you can have access to legal representation if you meet the eligibility requirements. So next slide, please. So what are the features of the program? So the State House LA County program, again, through its 20 or so service providers, delivers a plethora of components. So the first major component of this program is a public awareness campaign. And so what this looks like is really trying to ensure that the community, the public, is aware that this program exists. And so the way that they do this is through a mass digital media advertising campaign that is implemented through various platforms. So we do this through social media. We do this through advertisements on social media platforms. We also do this through emails, where we're trying to really reach the millions of tenants and households in various languages within the county. The second component of the program is direct tenant outreach and education to tenants living in vulnerable communities. And so what that looks like is we do virtual tenant know your rights workshops. And so making sure that individuals are being educated and informed of their rights as a tenant. So later on in this webinar, you will be hearing from one of the contractors that provide services under the Stay Housed umbrella program. And so these virtual Know Your Rights workshops are hosted by these various organizations, either legal service providers or community-based organizations, to provide you information about your rights as a tenant. We also do this direct tenant outreach through text messages, phone calls, and direct emails to provide you information on resources available through the Stay Housed program. The third component, which is one of the key and central components of the program, is legal services, which I will be delving into a little more detail in the next slide. Short-term rental assistance as well, so providing financial resources to tenants that might have fallen behind in rent and are in danger of being evicted either through an eviction case or because they've received some type of a notice from a landlord saying that they're behind in rent, and they need to remedy that. And so the last component of the program is making sure that individuals are receiving referrals and getting connected to other resources, either through the county or through the legal service providers or the community-based organizations that deliver services through the program. Next slide, please. So the two really core components of these programs that are most relevant to tenants, I think, are the legal services and the short-term rental assistance. And so, as I mentioned, the legal services are really there to create a level playing field for tenants that might be undergoing an eviction. And so there's various types of assistance. Well, actually, two types of legal assistance that are available to eligible households. And so, if you meet certain criteria, specifically income eligibility, you will be eligible for either of these two types of legal services. So the first one is limited scope legal representation. And so really the legal scope representation is meant to assist a tenant prior to having a formal eviction case that will go to court. So really trying to get assistance to a tenant before they get to that stage where they need legal representation in court. And so what those type of limited scope legal services include are such things as one-on-one legal consultations, document preparation in response to a termination of tenancy notice. So if a landlord has contacted a tenant either verbally or in writing, saying that you need to pay your back rent or to remedy whatever type of a violation you're having for your lease, this limited scope legal representation will assist you so that you can try to negotiate or resolve whatever dispute you're having with your landlord before having an actual eviction case or having to go to court. And lastly, there is a component of out-of-court dispute resolution and negotiation that can occur as part of this limited scope legal representation. And full scope legal representation, which is distinct from limited scope, is that you're getting comprehensive legal services. So in addition to all the services that you'd be getting through limited scope legal representation, you'd be getting representation in court, you'd be getting representation in any settlement negotiations that are going on related to an eviction case, and you're getting more comprehensive active defense against any landlord harassment or retaliation that you might be experiencing with your landlord. In addition, if you are eligible for full scope legal representation, you will also be eligible for short-term rental assistance. And so the short-term rental assistance is there to try to ensure that you can resolve any disputes that you're having because of any back rent that is due. So the Stay Housed LA County program provides up to $7,500 or 3 months in retroactive or proactive financial assistance, whichever is less. And so this type of assistance can be applied to rent, but it could also be applied to utilities, security deposits, or even relocation costs, depending on your particular situation. So next slide, please. So I've mentioned these two kind of tiers of legal services and assistance that you can receive, either the limited scope legal representation or the full scope legal representation and or the short-term rental assistance. So in order to be eligible for these types of services, you need to meet certain eligibility criteria. The first one being, and the most important one, is that you must reside within the County of LA. And so these programs are limited to residents of LA County only. And if you want to receive either limited scope or full scope legal representation, you should have either received some type of a formal notice from a landlord or complaint, either in writing or verbally, that you're behind on rent or that you're having some type of dispute with them because you're undergoing some type of COVID-19 related hardship. Or if you're experiencing some type of a harassment, your landlord is trying to intimidate you, trying to lock you out of your unit if you might have, been backed up in rent, or any other type of a housing issue. If you have any maintenance issues that your landlord isn't taking care of, one of these things would make you eligible potentially to receive legal assistance. And so, going more specifically now into the kind of income criteria for the limited scope legal representation or the full scope legal representation. So in order to be eligible for the limited scope legal representation, you have to make up to, or you can't make more than 80% of the area median income, which is being defined as $90,100 a year for a family of 4 or $63,100 a year for a single person household. Now, what I will make very clear is that no matter of your legal status in the country, you are not required to show legal proof of residency to be eligible. The way that we verify income eligibility is through a self-certification process. So as long as you can, fill out the forms and certify on your own what your income is, you will be eligible for these types of services as long as you meet the income eligibility criteria. Again, legal status is not going to be a bearing on whether or not you're eligible for these types of services. And secondly, if you wish to receive either full scope legal representation or short-term rental assistance, you have to not make more than 50% of the area median income, which is being defined as either $56,300 a year for a family of 4 or $39,450 a year for a single person household. If you receive public benefits, such as CalWorks, general relief, and other types of public benefits, that will automatically qualify you for services for short-term rental assistance and the full scope legal representation. Next slide, please. And so now that you have this overview of the services available to you under the Stay Housed program, how can you access it? So the main avenue for you to be able to access these services is by going to our website, which is stayhousedla.org. And so what you're seeing in front of you is the homepage for this website. Really, this is going to be your central avenue to access information about the program, to learn more about your rights, and to get legal help. And so this will be really your central avenue to access resources. However, this is not the only one. You will also be able to access resources through a dedicated hotline that we've set up just for the Stay Housed LA County program. And I'll provide that number at the end of the next slides that we'll be going over, where you can access services. In addition, you can also access our services through the Disasters Help Center that I talked about earlier in the presentation, or through the DCBA Housing and Tenant Hotline. And that number I will also repeat at the end of my presentation. So next slide, please. So on the home page, there will be 3 buttons, and one of them will be to learn more about your rights. So if you click that button, you will be then directed to the Know Your Rights page within the Stay Housed LA County website. And there you'll learn about the different eviction moratorium that are active. So there's one for the county, there's one for the state, and there's also a federal moratorium that was implemented by the CDC. And so you can learn basic information about those items on this page. And you can also visit our DCBA rent website to get even more detailed information about all of these different laws, regulations, and to know which local eviction moratorium might apply to you. So these are 2 great online resources for you to learn about your rights. Next slide, please. You can also learn more about your rights by signing up for a workshop. As I mentioned earlier, our service providers provide these regular workshops. And so if you click on the button on the home page to sign up for a workshop, it'll lead you to this page, and there'll be a listing of all the currently planned workshops and when they are and what topics they will cover. And so this is another great resource for you to learn more about your rights through these virtual Know Your Rights workshops. Next slide, please. And lastly, there is a button on the homepage that will connect you to another site, another page, should I say, for you to fill out a quick questionnaire to figure out what type of either legal assistance or other type of assistance you should be receiving. So this is an opportunity for you to kind of provide some answers to some brief questions to try to connect you to the right type of organization, either a legal service organization or a community-based organization. Next slide, please. And lastly, a way for you to stay connected with us and to learn more information is to either get email updates. So at the bottom of the homepage or any page within the Stay Housed LA County website, you'll see some buttons that are here on the slide that say Stay Connected. And that will link you to either the form where you can sign up for email updates or to one of our social media platforms. So we're on Facebook, Instagram, and Twitter, where we provide regular updates about the program and for you to get access to resources. So next slide, please. And so once again, I want to provide the information for you to be able to access all of the sort of services that I've talked about today. So again, your main avenue to get eviction defense services is through the Stay Housed LA County hotline or website. So that's up there. The hotline is 888-694-0040. The website, again, is www.stayhousedla.org. You can also contact the Department of Consumer and Business Affairs directly through our tenant hotline, which is 833-223-RENT, 7368, through email, rent@dcba.lacounty.gov, and through our website, rent.lacounty.gov. So again, thank you so much again for the opportunity to share this information with you. And we hope to connect with a lot of you that are needing services. Thank you.
Manny, thank you so much for that info-packed presentation, incredibly useful. And I also want to acknowledge your work on the Stay Housed LA program. Manny, for those of you who are not aware, was instrumental in getting the program off the ground. So thank you so much. And so I now want to give the floor to Scott Davis from the Inner City Law Center, who is going to discuss tenant defense and eviction preventions and protections. Scott, the floor is yours.
Great. Thank you very much, Dan, and thank you all for having me here. My name's Davis. I'm with the Tenant Defense Project at Inner City Law Center. And so we're living through a really difficult time here, and tenants are especially at risk. But there are some protections that have been enacted, and so we just want to give people an overview of what those protections are. So if you have problems with your landlord, you're aware. Next slide, please. Very briefly, Inner City Law Center is a nonprofit law firm providing free legal services to the most vulnerable residents here in Los Angeles. We were founded about 40 years ago on Skid Row, and we still have an office there. If you want to learn more about us or the services we offer, please go to our our website. Like I said, I'm from the Tenant Defense Project and do eviction defense work, but we offer a range of services. Next slide, please. Great. So briefly, what I want to talk about first is what tenant protections exist in Los Angeles and in California generally, and what those were before the pandemic, so that then we can talk about what tenant protections have been enacted specifically in response to the COVID-19 pandemic. And then I will also talk about a few immigrant-specific protections that exist and that are relevant for the landlord-tenant context. Next slide, please. Great. So prior to COVID, there were a range of tenant protections and laws that protected tenants from landlord harassment or evictions. And those laws come from a variety of sources. There are municipal codes, so your local city laws or county laws. There are state laws that can offer protection, and there are even some laws from the federal government. So there are a lot of different laws that relate to tenant protections and to landlord-tenant interactions. And in a lot of ways, they kind of either work together or they overlap. And so figuring out exactly what protections you have is actually somewhat complicated at times because different protections apply to different people. It'll depend on where you live, what kind of building you live in, whether it's a single family home or an apartment building, when that building was built. So figuring out exactly what protections apply to you can be very difficult. But there are two important types of protections to be aware of, and those are rent control protections and just cause eviction protections. Next slide, please. So briefly, rent control, which can also be known as anti-gouging protections, these are laws that limit the amount your landlord can increase the rent and how often they can do so. So without rent control, your landlord could, show up at the end of your lease and say, I'm going to increase the rent, 100%. I'm going to double the rent. Rent control is designed to prevent that from happening and to stabilize tenancies and, make it so your landlord can only increase the rent every year by a certain small amount. However, here in California, rent control does not protect the rent from being increased when your tenancy ends. So if you live in a unit and you've lived there for a few years and the rent is set at a certain rate, your landlord can only raise it so much. If you then leave and someone else is trying to move in, now the landlord can set the rent to whatever they want. So this creates some bad incentives at times for landlords where they, are limited by what they can raise the rent to with one tenant who's lived there for a while. But if they can get that tenant out of the unit, then they can raise the rent to whatever they want. So that leads to some landlords trying to force long-term tenants to leave so that they could then reset the rent to market rate. Next slide, please. Just cause protections are another important general type of tenant protections to be aware of. Without just cause protections, your landlord could basically evict you for whatever reason or for no reason at all. Just cause protections limit the reasons landlords can evict someone. So they're kind of a couple different types of just cause reasons. Some are at fault, some are no fault. Examples of at fault reasons would be not paying your rent, violating your lease, doing criminal activity at your apartment. And no fault reasons are reasons that the law says a landlord can terminate your tenancy even though you've done nothing wrong. The most common one of those is if your landlord wants to move into the unit that you're living in or to have a member of their family live there. That's a reason that they can evict you. And there are a couple others, such as complying with like a government order to clear out the building. But those are just general things to know about as far as at fault and no fault evictions. And so these are types of protections that exist in California and already existed prior to the coronavirus. Next slide, please. And so briefly, just so everyone's aware of what the process looks like, just so you can be aware of sort of what the next steps are if you ever get any kind of legal papers from your landlord. Before your landlord files an eviction or does anything, they've got to give you a written notice. And this notice is going to say what the problem is. So if you haven't paid a rent, it'll say you've got to pay rent in a certain amount of time or they'll start an eviction case. If you're violating the lease, it'll say you have to fix that lease violation or they'll file an eviction case. So this is designed to give you notice of what the problem is and a set time to fix that problem before it leads to an eviction. Once the time period in the notice expires, the landlord then can go file an eviction case with the court, and that's called an unlawful detainer case. And so then after that, you'll be served with more paperwork and you've got to answer in court their eviction case and their complaint if you want to fight the eviction. And generally, you only have 5 days from receiving that paperwork to then go to the court, fill out an answer, and tell your side of the story. Once you've answered, then the court will set a trial date. Generally, trial is expected to happen on that first court date, but the court will definitely encourage parties to settle. They would like to avoid trial. And as someone mentioned previously in the presentation, most landlords have legal representation, and most tenants generally do not. And so landlord attorneys will really try to steamroll unrepresented tenants and get them to either agree to a bad settlement or to try to take advantage of the process. And it's difficult for tenants. Like unlawful detainer court has a lot of strange rules, and most people wouldn't know about them unless they go to unlawful detainer court frequently. So luckily, we've got this State House LA program now, which provides free legal services to tenants. And this sort of is designed to level the playing field, to make tenants aware of their rights, to help tenants advocate for their rights, and to avoid them being, taken advantage of because they're not represented by attorneys. Next slide, please. Great. So turning now to some of the protections that have been enacted specifically in response to the coronavirus pandemic. Since March 2020, a lot of different agencies and different government actors have enacted different tenant protections because we're in this, unique circumstance. The goal of these is to keep tenants housed to reduce the spread of coronavirus, because if people are being evicted, that's just going to increase coming into contact with other people, increase the spread of coronavirus. If we have stay-at-home orders, it's really hard to stay at home if you don't have a home. So the goal of these is really to reduce the spread of coronavirus. And most of these protections only apply where you cannot pay your rent. They're really designed to reduce evictions for not paying your rent. Next slide, please. So California enacted a state law, AB 388, which relates to not being able to pay your rent during this pandemic. So what you can do is, if you're struggling to pay your rent, since March, you can take that off the table as a reason to evict you. The way you do that is you've got to give your landlord a declaration, which is basically a signed statement saying that the reason you can't pay your rent, or part of the reason you can't pay your rent, is because of coronavirus, whether it's you've lost your job or been furloughed because of COVID-19, whether you've reduced, your business has lost business because of the pandemic, whether you just have reduced hours. All of those things are coronavirus related reasons for you not to be able to pay your rent. And so I'm going to keep this somewhat general because I could get into the specifics, but then that would take much longer than I have here. But this is going to apply for the rental period from March 2020 through January 2021. And depending on which months you can't pay your rent, you may or may not have to pay a percentage of that. So if you can't pay your rent, and it was between March and August, if you sign that declaration, the landlord can never evict you for that rent. Now, they can collect it in small claims court. They can still sue you for it, but it cannot be used as a reason to evict you. If the rent you owe is from September of this year to January 2021, you will have to pay 25% of the rent that you owe for that period by the end of January 2021. But once you do that, the other 75% again will be, civil debt people can collect in small claims court, but it cannot be a basis for eviction. So as that last bullet says, if you sign these declarations and give them to your landlord, the money will still be owed, but it cannot be used as a reason to evict you. Next slide, please. The main other protection that exists and has come out recently is the CDC order. So in September, the CDC issued this order temporarily halting certain evictions nationwide. And so this only applies to evictions where you can't pay your rent. But and similarly to the California law, you have to fill out a declaration and give that to your landlord. But it's a little bit more general in what it applies to. It doesn't require specifically that the reason that you can't pay your rent is because of coronavirus or because of COVID-19 related economic issues. So if for whatever reason you can't pay your rent and it actually doesn't have to do with coronavirus, the CDC order may give you some protection that the California state law would not. Again, as I mentioned, you still have to sign in this declaration, although it is a different form. So please be aware of that. And the CDC order is going to be in effect through December 31st. And so when this comes up mostly is, especially for people who had eviction cases prior to the pandemic, some of those cases are now being heard in court. And the CDC order, even if all the other laws don't give people a protection for like their rent being late because it didn't occur during the pandemic, we can still use this CDC order to say, this is a non-payment case, there's an eviction, you can't evict them until the end of December. So this can at least give you a little bit extra time and not allow you to be evicted until the end of the year. Next slide, please. And briefly, I wanted to mention a few laws that already existed. These did not come about because of the pandemic, but they do specifically apply to immigrant communities and immigrant tenants. So a landlord cannot ask you or anyone in your household about their immigration or citizenship status. This is true both when you're applying to rent an apartment and you have to fill out the application form. It's also true once you're already living there. Like your landlord can't come by and ask you about your immigration status. It's also illegal for your landlord to report your immigration status to a government agency, to retaliate against you or harass you. The only exception to this is if they are being required to disclose that information because they've been subpoenaed or there's some kind of legal or court document that's basically requiring them to testify to what they know. But in general, your landlord cannot ask about your immigration status and cannot try to report it in order to harass you or retaliate against you. Next slide, please. So there are other protections that may apply, and so I would encourage everyone, if you want to see what applies specifically to your situation, to go to statehousedla.org, go to one of the Know Your Rights trainings. If you've gotten paperwork from your landlord, I encourage you to fill out the form so you can get connected with a legal service provider like Intercity Law Center. Because there are other protections that might affect you. Like LA County has rent freezes. There are certain limitations on other eviction cases if it's not about non-payment of rent, but it's about an extra occupant who's not on the lease or a pet that's not supposed to be there. You can get some protections for evictions brought for those reasons. But the most important thing is to remember protections vary by location. Like they'll be different for people in some parts of the county than others. And so that's why it's really important to either try to go to Know Your Rights training or if you have questions, go to the State House LA website and get connected with a legal service provider who can answer your specific questions. Next slide, please. Great. The last thing I wanted to talk about, and what may be like a specifically or particularly urgent, is what if the landlord's changing the locks on a unit? What if they're illegally trying to evict you? So your landlord can't just evict you on their own. They've got to go to court. They've got to go through the court process. They've got to get, certain papers from the court saying that they have the right to possession of the unit. Only then can they get you locked out, and the sheriff will come. Your landlord can't just do this on their own. So if they are evicting you by, changing the locks or kicking you out without going through this process, that is illegal. The best way to get help for that is to call the number that Mr. Ruiz mentioned. It's 888-694-0040. Generally, that number will direct you back to the website for almost everything else. But if you have an illegal lockout and your landlord's illegally locking out of your unit, you can call that number and follow the prompts, and you can talk to a person, and they will be able to get some assistance to try to deal with that situation. So just know that your landlord cannot lock you out of your unit just because. Next slide, please. I think that's about it. Yeah, so if anyone has questions, there's my email address. Feel free to reach out. You can also go to our website if you have other questions about the organization. And for all other questions, also State House LA and your rights trainings are a great resource. So I hope this helped. Thank y'all.
Thank you so much, Scott. Incredibly thorough, clear, and concise. Really appreciate the information. We're going to move immediately to Sam Lukin to discuss foreclosure prevention. Sam, the floor is yours.
Hi, thank you. Hello, everybody. So my name is Samuel Lukin. I work for the Foreclosure Prevention Unit in the Department of Consumer and Business Affairs. I've been there for 7 years, helping people with real estate complaints, foreclosure prevention services, and things like that. The first thing that I wanted to point out, and I think Manny kind of hit it without even putting the slide out there, but our mission has been since 1976 to promote a fair and vibrant marketplace. We serve consumers, businesses, and communities through education, advocacy, and complaint resolution. Next slide, please. So this is a brief overview of the agenda. I want to talk about a little bit the homeowner notification program, the overview of SB 62, our foreclosure prevention services that are in fact in-house, and then really the most of the presentation is going to talk about real estate complaints. Next slide. So the homeowner notification was created in 1996 to alert homeowners of new recorded documents that were recorded against a property that they either live in or they have interest in. That had applied to grant deeds and quitclaim deeds, which are only used to transfer interest or bring somebody onto title, and deeds of trust, which is the document used in California most commonly to secure a loan against a property. Next slide. Now, the homeowner notification program actually authorizes the Los Angeles County Recorder to mail a copy of those deeds or quitclaim deeds or deeds of trust within 30 days of that document being recorded. Now, that document is supposed to be mailed out to the property address and any mailing addresses that they have on file. They're required to collect a fee when the document is recorded so that this can be funded and sent out to the interested parties. Now, when SB 62 was recorded at the end of 2013, the homeowner notification program was expanded. And it was really to address the idea that the real estate bubble had burst and the economy was, the real estate economy and the home economy was trying to get back on its feet. But lack of notification for the common homeowner of what was happening in properties was missing. So now, instead of just sending deeds and quitclaim deeds and deeds of trust, the notice of default, which is the first step in the foreclosure process, and the notice of trustee sale, which is basically one of the last steps in the foreclosure process. Those documents were also going to be mailed out to the interested parties or whoever occupied the property. Next slide. Now, the reason why I did bring up SB 62, and it'll sort of tie into the rest of the presentation, but what that actually created was a way for our department to provide counseling on the California foreclosure process to anybody who is facing foreclosure. One of the things we are going to talk about is a lot of people did fall, to to individuals who were promising that they could help their situation. There were foreclosure rescue scams that were cheating a lot of people out of money, out of their homes, and picking up shop and taking off. We provided one-on-one assistance with property owners in communicating directly with their lenders to find out exactly what options they had in front of them in order to avoid foreclosure. At that time, the foreclosure rescue scams, and we'll get into that a little more, but they were saying that it would be illegal for somebody to foreclose. And there was a lot of bad information out there. What the SB 62 did create was a unit to make sure that that information was countered with the correct information and free assistance instead of being charged by somebody else. I know now there is an eviction moratorium, but at the time, tenants were renting properties and were going into foreclosure, and then somebody would knock on the door. I bought the property at the foreclosure auction, it's time to leave. And we were helping tenants reach out to the new property owners and sort of discuss what their options would be at that point in time. Next slide. So here we have a common list of real estate complaints. Now, I know originally we were looking at discussing the idea of real estate scams. Unfortunately, I think that the original title of the slideshow didn't really capture all the information that we would be able to give you. You know, I think that common real estate complaints would be better to discuss because not every complaint that our department receives is an actual scam. A scam would be something that was committed intentionally to maybe remove somebody from their money or even their property sometimes. You know, there are things like erroneous recordings you'll see here, indexing errors, you know, which can occur by mistake, human error. And I'll explain what an individual should do or should at least consider when they're faced with one or more of these issues. So when we're looking at an erroneous recording, that really talks about the idea that there was something put incorrectly in a document that was recorded with the Registrar Recorder's Office that was just put incorrectly. Whether or not it was malicious is for someone else to determine. Usually it happens when somebody who is inexperienced or maybe unfamiliar with preparing documents, and then they submit it to the Registrar Recorder's Office, it gets recorded, and then all of a sudden they realize, hey, wait a minute, we're getting calls from somebody else saying, why did you do this? You know, a common situation, just like the one below, a homeowner that maybe they intend to add a spouse onto their title or a family member, or maybe they put the property into a living trust. They make it to the point where, let's say the document shows that their names are spelled correctly and the actual situs address is spelled correctly. But then you get to the portion of what's called a property's legal description. Now, if a legal description is written incorrectly or it's not perfectly accurate, the document may be actually recognized as being attached or recorded against a different property, or a property that they have no interest in or they don't own. While this can create an issue for the person who's recording the document, because now they have to go redo it and probably hire somebody to do it right, which they usually should have done the first time. It's also going to create a problem if this document was attached to another property. It could create something like a cloud on title. And if the other person, receives a copy of this document and says, hey, wait a minute, you're my next door neighbor. Why did you record something against my property? I'm trying to sell my property and now there's a cloud on title, or I'm trying to refinance and the lender won't fund it. A lot of times we get these complaints, and what we like to tell people is if you're considering making a change, it might be a good idea, if you're not completely familiar with it, to hire a professional. Hire somebody who knows what they're doing and get it done right the first time. Next slide. So as I mentioned before with SB 62, the Registrar Recorder's Office does have to send copies of those certain documents that are recorded to property owners who are interested. Now, an indexing error well, I'll go over it right now, but so there's an organization that exists called CoreLogic. And what they do is they collect data from recorders' offices in counties all over the country. They collect and they compile the data and they make it available for a fee to anybody who might be interested, sort of like Netflix, right? You could log in, you could pull up basic information about a property, maybe the recent title transactions, loans that might be taken out if the property is in foreclosure, where it's located, who's the current owner, things like that. Usually very basic. The example here, it basically shows the way that certain properties are going to appear when you search them. Now, a property is going to have a legal description, it's going to have their address, and then it's going to have something called an APN number. Now, because CoreLogic collects this data from the recorder's office, they hire their staff to look at the document and input the data into their database. Now, if somebody miskeys an APN number, like you can see here, I'm not sure if everyone can see, but in the top right corner of the top box, the number ends in 018. Now, this was actually a file we had. The person who owns that top property had recorded a document against it. Now, when CoreLogic received it, they recorded it at the bottom where the APN number is 008. Now, in their database, the property is going to show that there's a new owner. And there are multitudes of organizations that subscribe to this service and depend on it. Real estate agents, title companies, certain escrow companies, anybody who wants to really. And it's going to trigger or what looks like a change in title. Now, it's important to remember that just because they input it incorrectly doesn't mean that that's the way it is. Okay. This data actually only reflects their accuracy or lack thereof. Now, if you do receive a document in the mail and you're unfamiliar with it and you recognize, hey, this isn't my property, our department actually is responsible for reaching out to CoreLogic when these errors occur, and then we have them correct. Next slide. Actually, you know what? I did miss a slide on forgery, but I'll go over it really quick. A lot of times we do get calls from individuals who received a document through the homeowner notification program saying that they never signed their house over to their sister, or maybe I never put my property in a trust, or I never took out a loan against the property. A lot of times, and especially unfortunately with senior citizens, they don't necessarily remember what exactly it is they did with their property, and it may not be malicious. Usually, we can go over the document with them and say, hey, did you put the property into a trust? And, you know, it sort of jogs their memory. Or did you take out a reverse mortgage? You know, I did do that. Did you do it maybe, you know, in October? Yeah, okay, let's go through that. That's what this is. And sometimes people forget. But there are cases when someone will admit, and they'll be pretty adamant that I've never done this. This is my brother's been threatening to take my house, or my next door neighbor, we've had these disputes for a long time, and they forged my signature. More often than not, it's going to take an additional portion of investigation on our part to figure out if this is a forgery or if there was anything else that was agreed upon when this document was reported. But once we figure that out, usually our department recommends that you fill out a police report with your local police station. The larger municipalities in the county do have real estate fraud investigation units, and they're actually pretty effective. We also recommend that you consult with an attorney because the foreclosure process in California is about 110 to 120 days. And if you're waiting on either the police or a detective or someone else, and you don't hire an attorney to get something done, you could potentially have a situation that's spinning out of control. So now let's talk a little bit about the foreclosure rescue services. So these sort of rules here are really important to remember, and they're sort of red flags. In California, it is in fact illegal to charge a property owner upfront for foreclosure rescue services. So if anybody ever asks you or tells you that, okay, yeah, I'm going to guarantee you a loan modification, and you know you're not going to have to pay the bank, we're going to sue them, we're going to do all this, but I just need $3,000 now. It doesn't work that way. Okay, it's illegal. It's against the Homeowner Bill of Rights and a multitude of other laws. Some organizations are going to claim that they can help property owners, what's called a forensic audit. That's a real common term, and they can provide, you know, instances that the loan contains elements of fraud, and we're going to sue, and you're not going to have to pay this. There are many organizations, just like our department, HUD certified agencies, that provide foreclosure prevention services free of charge. And it's important to sort of realize that if you are stuck in that situation, contact a government agency or an agency that's certified by the federal government, the Housing and Urban Development, because you're going to get the best straight answer, usually the best help. Next slide. The next portion of common complaints that we get is billing disputes. Usually it's any complaint that concerns the application of payment or the overall accounting of a loan. We get people that say, hey, I've paid my mortgage for 6 months and it's only showing I've been paid for 4. But then they don't tell you that they were 2 months behind when they started paying for 4. the way that, the payments are applied, it's the first missed payment, things like that. This applies to any a traditional mortgage, home equity line of credit, or reverse mortgage, hard money loans. We do take complaints against that. Usually, it just like the indexing errors, it can be a human error on the lender side, and we found that. But that is, again, something that we do hear a lot of, and that we do take complaints against. Next slide. So this is something that sort of came up recently. PACE, it stands for Property Assessed Clean Energy. The program it's relatively new, like I said, in the state of California, especially for residential properties. It's designed to address climate change. Actually, that's what the original bill brought up, and it was meant to provide funds to make certain energy efficient upgrades to real property without the owner having to pay any upfront fees. The program was designed to have what's called a PACE administrator certify certain home improvement contractors. When a home improvement contractor would engage with the homeowner, they would verify the homeowner's ability to pay off the loan within reason, and then they would fund the project directly. And then the homeowner would actually have to pay back the funding or that loan as a line item on their property tax bill. Unfortunately, somewhere along the line, certain bad actors entered the arena. Around 2014, our office began seeing complaints from property owners claiming they were not properly explained the function of the financing. Amongst other things, they had complaints about the perceived quality of the home improvement projects. They didn't understand the government's role in collecting the loan to the property tax bill. Things were just not necessarily explained. A lot of holes in the law, and people were getting away with a lot of things. Now, our department will take complaints against PACE administrators. However, it's important to remember that the Contractor State License Board, or the CSLB, they're required to license, regulate, and discipline licensed contractors in the state of California. They hold information against about their bond, about how many complaints they received, a lot of other things. Additionally, the Department of Business Oversight, the State Department, they have now begun taking complaints against PACE administrators. Okay, one more slide, I believe. Oh, I think we might have missed one.
Sam, we're at time. We're actually a couple minutes over, so thank you so much. Incredibly useful info. Really appreciate it. There's the contact information for folks in need of foreclosure prevention support. Jorge, if you can advance 3 slides, please. Right there. So just want to note before we close, one time-sensitive program. This is not a county service, but the City of Los Angeles, the LA Department of Water and Power has a program to provide emergency one-time assistance for folks struggling to pay their utility bills. And the application is due on the 22nd. So it is due in just 3 days for folks to be aware. This is one-time emergency disaster assistance. Folks are eligible regardless of immigration status, and there is no public charge impact on individuals who receive this, who apply for and receive this benefit. With that, I want to, if we can advance to the last slide, please. I just want to note that the recording for the found on the Office of Immigrant Affairs Facebook page. The slide deck will also be posted and circulated by email. Please follow us on Facebook and Twitter for future webinars, other events, and immigration updates. Finally, I want to thank all of our excellent speakers, including our external speaker, Scott Davis from the Inner City Law Center, so much. Really want to thank Jorge Anaya from the Office of Emergency Management for coordinating the event today. And then I want to thank our outstanding Fuse Executive Advisor, Michael Nobleza, along with Natalie Riguero of the Office of Immigrant Affairs for putting together today's webinar. Thank all of you for participating. Thank you so much. Have a wonderful day.